The abatement process begins with the taxpayers filing an application with the assessors for an abatement of real or personal property tax. The application must be on a form approved by the Commissioner of Revenue. The taxpayer cannot just send a letter, email, or other communication saying the taxpayer is seeking an abatement. State Tax Form 128 is the form approved by the department for filing abatement applications. Abatement applications are confidential. The application includes any attachments or information submitted by the taxpayer to support the application. The applications are exempt from disclosure under the Public Records Law. Access to the applications is limited to the taxpayer who filed the application or the taxpayer's designated representative, you and your assessing staff, Department of Revenue staff, and other state and local officials and private auditors required to do so to carry out their official or contractual duties. State Tax Form 128 is the form approved by the Commissioner of Revenue for use by taxpayers applying for abatement of their local real and personal property taxes. Use of an approved form is required. In order to apply for abatement, the applicant must have standing to dispute the assessed tax. The applicant must be aggrieved, that is, adversely impacted by the assessment. It is the assessment of the actual tax for the fiscal year that triggers the right to seek an abatement. The actual tax is the portion of tax obligation that falls due after the tax rate is set for the fiscal year. Most abatement claims are filed by the assessed owners of property, who clearly have standing. If a person or entity owns real estate on the January 1st assessment date, the tax is assessed to that person or entity who has legal obligation to pay it. If a person or entity acquires ownership of a parcel of real property after January 1st, the tax will be assessed to the owner on January 1st. However, the new owner can have the property taken by the city or town if the tax is not paid, which gives the new owner an interest in being able to dispute the tax. The owner who acquires after January 1st steps into the shoes of the assessed owner and has standing to apply for abatement. An assessed or current owner is not necessarily required to pay the tax before applying to the assessors for abatement. As you will learn later, the owner may need to pay all or part of the tax in order to appeal the assessor's decision on their application. Several other parties with interests in the amount of the tax can apply for abatement. First, if the property owner has died and his or her ownership interest has passed to his or her estate, a personal representative of the estate or trustee under a will stands in the deceased owner's place and can apply for abatement. Second, a tenant of real estate who is paying rent and under obligation to pay more than one-half of the taxes for the property has standing to seek abatement. The lease must specify the tenant's obligation to pay more than half the taxes. The tax must be paid to entitle a tenant to apply for abatement. However, a lessee of personal property does not have standing to apply for abatement regardless of his or her obligations to pay the tax. Third, the holder of a mortgage on the real estate, the mortgagee, who has paid at least half the tax, may apply for an abatement during a narrow window of time. The mortgagee can apply during the last 10 days of the abatement period before the deadline, but only if the owner has not already applied. Finally, other parties with an interest in the real estate are in possession of it, for example, a remainder man or a lien holder, who pay the tax on the property may apply for abatement. Let's take a minute to review the basic property tax billing and payment cycles, as the cycle used by a city or town determines the deadline for their taxpayers to file abatement applications with the assessors. Cities and towns may use quarterly or semi-annual payment systems. Depending on the system, the taxpayer may pay the tax they owe for the fiscal year in 4 or 2 installments. Most cities and towns use the quarterly payment system. In those cities and towns, a preliminary tax bill based on the prior year's tax is issued in June and is due in 2 installments on August 1st and November 1st. After the tax rate is set and you make your annual commitment to the collector, the actual tax bill is issued and the balance owed is due in 2 installments on February 1st and May 1st. In most semi-annual communities, the actual tax bill is due in 2 installments on November 1st or 30 days after the mailing of the bills, if later. The second installment is due May 1st. Note that some semi-annual communities may issue a preliminary bill followed by the actual tax bill for the balance, but the due dates depend on the type of semi-annual system. To establish when tax bills were mailed, the collector should prepare an affidavit as to time of sending tax bills, State Tax Form 214. The date shown in the affidavit is the date when all bills for taxes included in the commitment have been mailed. The collector should give a copy of the affidavit to the assessors, so you will also have a record of that date. Abatement applications must be filed on time. You only have jurisdiction, that is, legal authority, to grant or deny abatements if the taxpayer filed the application on or before the due date. That means you cannot extend the deadline or act on applications filed after the deadline. The abatement application deadline is the date that the first installment of the actual tax is due. For cities and towns using the quarterly payment system, the date is usually February 1st. In cities and towns that send out semi-annual tax bills, it is usually November 1st, or 30 days after the actual tax bills are mailed, if later. Note that if the application deadline falls on a Saturday, Sunday, or legal holiday, it is automatically extended to the next business day. If there is a weather emergency and city or town hall closes for the deadline day in the manner required by charter, the deadline moves to the next day city or town hall opens. Taxpayers may file their abatement applications with the assessors in person or by mail, delivery service, fax, or email. You do not have to receive an application form with an original signature. The purpose of the application is simply to put you on notice that the taxpayer is disputing the tax. Applications that arrive in your office by the close of business on the due date are timely and you have jurisdiction to act on them. You do not have jurisdiction, however, if the application was emailed to your office after the close of business on the due date or faxed to the collector before the deadline by mistake, but not delivered to your office after the deadline. An application received in your office after the deadline is only timely if it was mailed, properly addressed to your office, and has a postmark affixed by the U.S. Postal Service that is dated on or before the due date. So, for example, an application for abatement in a quarterly community that is postmarked February 1st and addressed to the assessors, but received later, is treated as a timely filed application. You must keep a copy of the envelope in which an abatement application was mailed when it arrives after the deadline. Note that the postmark rule does not apply to applications delivered by private delivery services like FedEx or UPS. If an abatement application is sent by FedEx, for example, the date the application is received in your office is the filing date. Also note that the postmark must be applied to the envelope in which the application arrives by the U.S. Postal Service. A postage meter date stamp is not a United States Postal Service postmark. As we discussed earlier, the abatement process is used to put into effect full and partial exemptions for which the taxpayer qualifies. The deadline for applying for personal exemptions for seniors, veterans, blind persons, and others, and tax deferrals for seniors and persons with temporary financial hardships is April 1st, or 3 months after the bills are mailed if the date is later. That deadline also applies to residential and small commercial exemptions adopted by a city or town as part of its property tax classification decision. Applications for all other exemptions are due the date abatement applications are due. That is, the date the first installment payment of the actual tax is due. Let's review what we have learned in this lesson. The abatement process begins with the taxpayer applying in writing to the assessors on a form approved by the Department of Revenue. The State Tax Form 128 is the approved form that must be used. Abatement applications are confidential and are not subject to disclosure under the Public Records Law. The applications and supporting documentation are available only to the taxpayer, you, and your staff, Department of Revenue staff, and certain other officials, including private auditors who need them to carry out their duties. To apply for abatement, an applicant must be aggrieved by the tax being disputed. An assessed or current owner is not necessarily required to pay any of the tax before applying to the assessors. There are strict deadlines for taxpayers to apply for abatements and exemptions. If a taxpayer does not apply on or before this deadline, you cannot act on the application.